the act of acceptance, we will see that while the corporate seals on both those documents are identical, the signatures of the one and the same person, for unknown reason, are completely different. And therefore, for taking into account the standard of consideration on their face, those documents are contradictory, and therefore these presentations may not be considered as compliant. If the tribunal has any questions concerning the Acceptance Act, I would be happy to answer.
In terms of the seal, does the respondent place so much reliance on the claimants or on the seal? Can you elaborate why we should not do this? I understand we are not contesting the fault. Neither you nor your client, neither bank nor my contest the authenticity of the seal.
Yes, we do not contend the authenticity of the seal, and it is also stated in the clarification to the case that the corporate seal is real. However, our position on this particular issue is that the corporate seal alone is not enough to be considered to consider this document as compliant. And the corporate seal in this case does indicate that the buyer is supposed to be a party to the acceptance. However, the signature does not allow us to identify that this document was signed for or on behalf of the buyer. In this regard, we ask the tribunal to apply the rule of the ICC's country, which is applicable to the bill of lading, and also may be applicable by analogy to the acceptance. And this rule says that any signature by the master, owner, charterer, or its agent must be identified as such. However, in this particular case, the signature at the last page of the Acceptance Act is stated as if it is the signature of Mr. Ivan Ivas. However, it is different from his signature on the shipbuilding contract, and we have no clarifications on the identity or the authority of this another person who signed.
How many signatures is a person could have?
We assume that the person could have several kinds of signatures. However, the standard of the examination by the bank, which is just the examination on their face, does not allow us to consider this acceptance as compliant.
Okay, related to the examination of this, here's the document where you have two elements. One is corporate seal, each seven. And second is the signature, which is not available. As a very precaution, you ask your client to comment as a presumptive document. And your client said, well, it was not my signature, right? Did you ask him why it was not his signature but his seal?
No, we did not ask the buyer on this fact. And we know from the materials of the case that the position of the buyer, that though it was present during the this acceptance of the yacht, he did not sign the document.
And you did not ask whether he accepted the yacht?
We did not ask the buyer on this fact. However, the bank is not concerned with the relations between the seller and the buyer. And even though we know from the facts, and we do not contest that the yard is now being used, and the buyer already has the ship safety certificate, we may not take it into consideration, because the bank is bound by the strict documentary compliance principle and the autonomy principle, and it may not be concerned by that fact. And we also would like to turn the attention of the tribunal to the international standard banking practice in the ICC publication number 745. And here in the paragraph 4, it is said that a lot of problems with the letter of credit arises because the respective parties did not reach the agreement on the text of the letter of credit. And to reach the agreement on the documents and the terms for the presentation of these documents. However, in this particular case, even if the letter of credit which was issued was not correspondent to the agreement, there is a special procedure of amendments to the letter of credit. After the 5th March 2015 till the 7th March 2016, which is a year, the representatives of the seller did not address the bank to ask for the amendment.
Without prejudice, one interpretation possible that can be given that the contract prevails until the documentation is run.
Yes, sure.
That's confirmation.
Just to follow up on my complicated question, because the position of the seller is, if I understood it correctly, there was no need to clarify in terms of letter of credit, because it says that that shipbuilding contract should have full effect with regard to the terms of this letter of credit, and because shipbuilding contract has a different list of documents, so the seller was guided by this list of documents and not by the letter of credit. Is it correct?
Indeed, this is the position of the claimant. However, under the Article 4 of the UCP 600, even if the reference to the contract exists in the letter of credit, this may not bound the bank and does not create any applications. And therefore, we may not refer to the Article 231B of the shipbuilding contract. And the only list of documents that the bank take into consideration is the list of documents in the letter of credit. And we do
Where is that? That's UCP 600 which?
it is the Article 4 of the UCP 600, which says that as long as the credit by its nature is a separate transaction, bank is in no way concerned with or bound by the underlying contract, even if there is a reference. And therefore, if we consider this paragraph 10 as a reference, it is void with regard to the discrepancies of the documents. And also would like to underline that even if the list of documents that was agreed between the buyer and the seller was different to the documents that we see in the text of letter of credit, it firstly has the possibility to amend, and also, even if it was the bad faith of the buyer, but the trust in the bank has no responsibility for the bad faith of another person under the Article 34 of the UCP 600. Honorable members of the tribunal, if you do not have any questions concerning the ship safety certificate, I would like to move to the question of the notification. It is true that the Article 16 of the UCP 600 stipulates that when the bank sees any discrepancies in the documents, it has a right to issue a notice to the seller, to the beneficiary, and it is obliged to list in this notice 3 points. Firstly, that it is refusing to honor the presentation. Secondly, why it is refusing to honor the presentation, and then the information concerning what the bank is going to do with the documents. And we do not deny that we have no information in this particular notice concerning what is going to happen with these documents because of the refusal. However, we would like to refer this honorable tribunal to the previous revision of the UCP 600, and it was the UCP 500. The Article 16 in this particular revision has listed the same requirements. However, the conclusions and the consequences of the violation was different. And the bank was at that time precluded to claim the discrepancies, not because it has not noticed about the information concerning what it was going to do with the document, but also if it did not fulfill the obligation to give this document back or to give it for the disposal of the beneficiaries. And the court practice after the change of this particular article did not change its position on the obligation of the bank. In the case of a banking trust company versus the state of India in the United Kingdom, court has stipulated that the aim of this particular obligation of the bank is to give the beneficiary the possibility to correct the documents and to make another presentation. In our case, as long as the claimant has no problem with the providing the honorable tribunal with the documents in order to resolve the dispute, and we have no indication that those documents were copies, we submit that the bank has fulfilled its obligation to give these documents back, and also the claimant did not ask the tribunal to help them with the taking these documents back from the bank. And therefore, we ask the tribunal not to take into consideration the formal violation of the Article 16 as long as the obligation was fulfilled. And taking into account the above arguments, the respondent asked the tribunal to rule that this presentation was not proper, and therefore the bank has the right to receive the payment. But we also submit that there are other reasons for the bank to refuse the payment, and it is also the fraud rule. The fraud rule is the proper exception from the independence principle of the letter of credit. And there was the ICC case that has considered the LC fraud issue in the 1977 between the Bank of Thailand versus the Bank of Spain. And in this case, similar to our situation, the bank has refused to honor the presentation which is based on the fraudulent documents. And the arbitrator in this particular case has upheld the considerations of the bank, because the fraudulent document as well as the documents...
In that case, was there positive evidence or not that those documents were forged?
Yes, there was the evidence as the consideration.
In this case, do we have similar evidence?
In this particular case, the bank states that the simple comparison of the documents and also the fact that we know from the case, from the clarifications, that there was no other representative of that the Manifestum Limited has no other representative. We say that this evidence may be appropriate to rule with regard to fraud.
The ICC case you referred to, was there fraud in the transaction or fraud in the documents?
Only the fraud in the documents, Mr. Arbitrator, and we would like to underline that we are not relying to the wide concept of fraud, which also includes the fraud in the underlying contract. Because this concept is only upheld by the courts of the United States and may pose a serious violation to the independence principle of the letters of credit. And taking into...
How would you conclude?
I have presented all of the arguments of the respondent and taking into account all of the above mentioned arguments, we ask the court, we ask this honorable tribunal to rule that the claimant has no right to the payment of $11 million and also the related interest. And we also ask the tribunal to rule that the arbitration costs and also the cost of the legal representation shall be allocated at the expense of the claimant.
Thank you very much. Any questions?
Members of the tribunal, a main premise of the respondent's case is that its rejection was made in accordance with the ICC 600. However, the bank did not follow these principles. The certainty of letters of credit to facilitate international commerce is maintained through on-their-face review by neutral banks. This guarantees predictability and efficiency. However, these goals cannot be achieved when banks involve outside parties and evidence to deny payment. As claimant has met its obligations under the letter of credit and the shipbuilding contract, and respondent has not honored its obligations under the letter of credit or international standard banking practice, we respectfully ask this tribunal for relief. Thank you.
Thank you very much. Anyone else?
Yes, the members of the tribunal, with regard to the allegations of the claimant concerning the violation of the UCP 600 by the court, by the bank, we submit that international standard banking practice limits the responsibility of the bank with regard to the instructions which it takes from the applicant. And as long as the applicant and the beneficiary are the parties who oblige to reach the agreement on the text, the bank has no responsibility for the discrepancies between the contract and the letter of credit, which resulted in the situation in our dispute. And the bank, though it has the right to amend the letter of credit, was not obliged to do so. And therefore, being bound by the strict documentary compliance principle and also the independence principle, the way the bank acted was the only proper and valid way. And with regard to the on-their-face examination of the document, even though the authority of the person who signed this document was not supposed to be examined by the bank, we would like to turn to the fourth rule again and say that as it was underlined by the Darrow in his work, Documentary Credits, no system can be effective if it is blind to something what is manifestly unreasonable. And if the bank knows that there are no representatives and sees manifestly falsified signature, it has no other ways to act as to refuse to honor presentation. This concludes the presentation of the respondent.
Very good. Any questions? Okay, thank you very much, both teams. We are not planning to give you any result of our deliberations, which